Parliament for Abuakwa South, very senior member of Ghana's Parliament and, of course, of the majority group. Hello, good evening, sir. Welcome to Eyewitness News. What's your own view as a senior member of the caucus and, of course, a senior lawyer as well on the current impasse between the office of the Speaker and the presidency in respect of assenting to bills and approving of president's nominees?
Well, it's very unfortunate that there seems to be a collusion cause between the executive and then the head of Parliament in relation to what I might perceive as a fundamental error on the part of Mr. Speaker. In the first instance, the President was saying that by reason of some processes filed in the Supreme Court, he doesn't believe that we should refer to him the Human Sexual Rights and Family Values Bill 2024 for assent, because there is a pending injunction in relation to two suits in the Supreme Court. If you ask me sincerely, what the President was trying to say that I don't want to prejudge what is pending before the Supreme Court. And therefore, if you could hold your horses and not transmit the bill to me, that is what the way to go. In the first instance, most people believe that the President is trying to be law-abiding. Number two, the President is trying to respect the apex court so that the President does not prejudge what's there. Now, the Speaker believes that the President's letter is an affront to the dignity of Parliament. And Mr. Speaker is also of the view that that amounts to contempt, because the President cannot bring such a letter to Parliament. And because of that, if the President is trying to respect the processes, the injunctive process of the Supreme Court, that is up to the President, but that is an affront to Parliament. Most of us believe that that cannot be the case at all. A law-abiding and law-respecting president cannot be held to ransom. Even if he has made an error, you cannot find anywhere in the Constitution that the president has violated. There's no provision in the Constitution that offends against the letter from the office of president. And the Speaker then does something which is very frightening. The Speaker comes out to say that in equal measure, as we are respecting the injunctive processes in the Supreme Court, I will also not attend to your nominees and aid you to have them passed, for the simple reason that I also have an injunction at the instance of Honorable Tafia Mapo pending before the Supreme Court. It turns out that is not true. That is a very, very serious matter, for the simple reason that at the level of intellectual elegance of the Speaker, fundamental errors cannot be committed. So I am of the humble view that when men of renown should see palpable errors on their part, what they should do is to buckle and probably say, I'm sorry, I think I was misled or something like that, so that the business of government will not come to an unfortunate halt because of an obvious error coming from the Speaker. So I believe that if I were Mr. Speaker, I'll eat humble pie and say that, look, the foundation of my action is not, valid. There's no injunction restraining the Parliament from considering the nominees of the President. Because the Tafia Mapo case relates to a different matter altogether. He was of the view that what the President says is revoked the appointments of some ministers. He couldn't reshuffle them. That is his view. He's entitled, and so that is contested. We don't see how that will impinge on, the ministerial nominees going through. So that is my sense of the whole matter.
I see, but people also raise issues about the president's consistency in principle. If he was acting in view of the principle, people have questioned that is he not the same person who went ahead to deal with the e-levy bill when indeed the matter had gone to the Supreme Court. I think it was a minority or a group that took the matter to the Supreme Court. He went ahead and did it, but the same processes or the same injunctive tools of the court were invoked So where lies the principle? That is one. Number two, you make mention of the speaker's, you call it a dangerous thing he did by saying he's been, there's an injunction application has been filed when that's not the case. The president also recently, when he met the diplomatic group at Pediasi or so, after the bill was passed in Parliament, made mention of the fact that he was aware that a private citizen had gone to the Supreme Court to challenge the constitutionality of the bill, when at the time he was making that comment, the registrar suit had not been filed. And it was quite difficult for the president to know that a private citizen was preparing to go to the Supreme Court on a matter like this. So, people question the consistency in all of this.
Well, I don't see any values that we are espousing, whether two wrongs will make one right. And bear in mind, I don't have the full factor for the president's relationship, which is skies and matter independence of it. But here I am, in the context of what happened yesterday. That's a palpable wrong. If the president should make a million mistakes, it doesn't entitle anybody to also make mistakes. And you can't say that the president has made a million mistakes, so let me do another one, which is so egregious and fundamental in terms of what you are turning out to Parliament, and which in a large measure is the foundation of your action. So please, you shouldn't confuse issues. Every man is prone to error. What we need for the sanity of the state, for men to concede ahead. And when you do that, then we know that those who are in authority are prepared to correct errors. And then we move on. But to say that there is a tendency of an executive process in the Supreme Court in relation to the Tavia Mako case, and when there is none, my brother, I don't know what you want to import into this equation and justify that the president has made some mistakes and therefore he should also do the same. No,
I'm not. I'm just trying to point out what people have called inconsistency. But be that as it may, there's issue that there's also the matter of whether the president should not have received it, because there was nothing stopping him from receiving it. What the injunction application sought to do was to injunct Parliament from transmitting it. So if anybody was going to be in contempt of court at all, that should be Parliament or the Speaker. So leave that to them and deal with yourself. You receive it, nothing stops you from receiving it. But he decided not to. So you don't think if he had just received it and said, okay, I've received it, but I'm awaiting the decision of the Supreme Court, you don't think that would have, solved all these matters, or that wouldn't have caused the storm we're seeing?
Well, I have said, and I still believe that maybe the president was nervous about the pendency of the matter in the Supreme Court. You can surmise that it's a law-abiding president. Maybe he didn't perceive it properly. Nevertheless, the letter came. Would it entitle anybody on the foundations of wrong evidence say that the ministerial nomination should not be approved? That is where the issue is. How can anybody say that even the president is wrong, which I believe in this case is not wrong because it's not violated in the law? And what he wrote to Parliament is not binding on Parliament, because the president cannot fetter Parliament from working. We know that as a fact. How do you justify what you said as pending in the Supreme Court, which are turned out not to be true? That is the real issue. But when you are trying to talk about tit for tat and people believe that, okay, the president is in error and therefore somebody is also should justify his errors, that will not help in the way you are doing that democratic governance at all. I don't believe it's right to even compare the two issues. So what it means is that on the fundamental point of error, the whole army of ministers who should be approved to go and help in the running of the state has been checkmated. Not because of law, but because of error. How can we entertain that? And that is my concern. I hold the speaker, to be very honest with you, in the highest esteem. I find him a very knowledgeable speaker. But let me tell you, I'm always nervous about people who do not want to concede their mistakes. It is only God who cannot make a mistake. So when you make a mistake, please, for Christ's sake, say, I got it all wrong. Can we remedy it? So that you continue with the business of government. Because now, we didn't consider the ministerial nominees, and the House was suspended. And it was not only that. There were some loans that had to be approved, so that we continue to have some forex, and then that will show up our city. They were not considered at all. In the fever of the moment, he just again and left us.
I see. So now, where do we draw the line? People have also said that we need to draw the line somewhere about issues about injunction application. Of course, I'm aware of the two schools of thought, but it does appear that the school gaining dominance these days is the one that says that once the application is filed, it operates as a stay on the processes, etc. But should that also be the case for the organs of government or the arms of government, for example? So somebody doesn't like something that is about to happen, the person runs to the Supreme Court. It could be on a frivolous matter, and then files an injunction application. That, by filing of that application, it holds the process and it stays the process. Is that the way we should be looking at it? Or we should say, no, that we should rethink this whole thing and make some exceptions? What's your honest view as a senior lawyer and as a lawmaker?
You see, these matters are the preserve of the Supreme Court. You understand? In your studio and where I'm speaking from, our opinions will not matter. It is only judicial pronouncement that we should abide by. And guess what? You cannot stop people from messing up with the system. Like you rightly said, somebody believes that, oh, okay, let me just have some funny action file and let me couple with an injunction just to see whether I'll be able to stop some shenanigans. So I wouldn't want to say too many times, but the Supreme Court has made some pronouncements. Let's go into those pronouncements and see whether it is right for anybody to injunct Parliament from doing his work, or on another level, whether it is right for anybody to injunct the President from doing his work. I think the Supreme Court has come out with some decisions that say that it is averse to that process. But in this context, with the greatest of respect, where there is no injunction pending, then we cannot even make these arguments. There is the monumental error which has been committed. If I told you that there's a pending injunction application and it turned out to be false, you understand? If you ask me sincerely, and I've told you I hold this particular in the highest esteem, it's to say, oh, I got this wrong. And I'm telling you, I'm very nervous to meet a man who says I will never get it wrong. And then we remedy it so that probably this house will be recalled. So that the government business will continue, because the House of Parliament does not exist to have a collusion cause with the executive. You see, the trinity in the democratic architecture are supposed to have complementarity. They complement each other. They aid each other, so that we can have democracy having a very seamless operation. But where it is obvious that on the ground of a very huge error, the speaker seems to sort of hijack the power of Parliament, and the executive cannot have the full complement of its ministers to aid the president in the running of the state. It leaves much to be done. So please, for Christ's sake, I don't want to do jurisprudence on your studio, but if the evidence is staring at the speaker in the face, that look, this is what's happening, then I am of the humble view that in his exalted place, you should say that, look, I think I made an error. Parliament should come back and let's do the government business, and now end the matter.
I see. I take note of the fact that a lot of the issues you have been on the speaker side when there are two parties in this matter, but that's fine. How about the claim that the president is gradually establishing a pattern of behavior in terms of his decisions or otherwise, his decision to accent to the bill, to bills or otherwise? So, for example, the witchcraft bill is being talked about, and the death penalty bill is also being talked about. The president, refused simply to accent to them, stating issues of private members' bills, etc., when indeed he had accented to an earlier one. So again, the issue about consistency comes up. Any view on those ones?
Well, I will not say that there is a pattern from the president end to sort of frustrate the processes of assenting to those. Even if he does that, you understand, he can bring it to his attention in a very civil engagement. We should not say, and I'm not saying that is the state of affairs, the errors of the president, or if you like, his tactics, if you like, to anger the legislature so much that let's frustrate him in what he's doing. If the president is doing something which is, if you like, unconstitutional, there are processes to bring the president to order. But we will lower the standards of governance to say, oh, let's do a tit for tat. Let's ensure that we frustrate his work, because we send some bills to him and he doesn't want to consent to those bills. I don't believe that's the way to go. You can always, even as a house, match to the presidency with a speaker as our boss. And the president, we want to have a tete-a-tete with you. He believes that these are matters of grave concern, and you've done it once, you've done it twice. You believe these are the areas of error. But praising the president publicly or doing things to let the president look bad is not the way to go. That's my view. Yes, it's not the way to go. If you say that, you know what you're doing, you want to point your relationship with the president, but that is not your role. A poisoned relationship with the speaker and the presidency will not augur well for democracy, period.
I see. Also, how about people who think that the speaker may be getting frustrated by some of these things? Anti-witchcraft bill, death penalty, now anti-LGBT. He may be getting frustrated by how things are panning out. And indeed, he is one we've seen to hold dear the doctrine of separation of powers, etc. Won't you call this parliamentary assertiveness? And as a lawmaker, this should make you so happy that indeed we now have a speaker who is able to assert the views of Parliament and do so forcefully.
Well, in so doing, you don't commit errors too. Trying to let the president wake up to your sense of the passing of laws. Make sure it doesn't become feverish. You see, when we say the speaker is getting frustrated, so frustration should yield to anger, and anger should yield to error. Is that where we want to go? The speaker is a very experienced man. To be saying that I'm frustrated because the president is not doing what I expect him to do. When the president is doing what the speaker is not expecting him to do, there can be what we call serious engagement. I am saying that the two men are not, excuse me to say, boys in democracy. They are both experienced. The president is not cheap, and the speaker is not a juvenile when it comes to democracy. So if the speaker believes that, oh, let the leadership have an appointment with the president, and let's engage the president on what we perceive as a pattern of frustrating the passage of bills. And let's hear the president. For all you know, understanding will dawn, and then we go into the chamber to do what is right. But when the speaker sits in judgment over the president in the chamber, and the president is not there to respond, I am of the view that then the relationship is degenerating. For democracy. Yeah, I
see. We understand there are frantic efforts to recall Parliament to attend to the outstanding matters. Any confirmation of that, sir?
Sir, I don't have any sense of that, but that's the way to go. In the face of an error, I know that the speaker will not cook lies to do what he did. I believe him. I have a lot of respect for the speaker that it might be a genuine error. When we see a genuine error, let's correct it. And
very well.
Let's recall Parliament to do what is needful.
Very well. We're also picking up signals that the minority are signaling their intention to institute impeachment proceedings. Have you caught wind of any such information against the president?
Oh my God. Over this matter? Over what?
I think over this matter, and generally matters of state, that he is not running the affairs of state properly. But this obviously is a trigger.
I say it's not propaganda. You see, and grandstanding. You understand? The opposition can even write a very simple note and turn on the light if they believe that the president is in error. You see,
all right.
well, some of these things, I mean, I don't know how you will succeed. You see, if the president is in error, does it amount to a ground for impeachment? Do you impeach a man because he's in error? Which a lot of people believe he's not in error. That is his view. And in a democracy, do not be averse to the views of others. Immediately you have that poster, you are being dictatorial. If the president doesn't think, let's impeach him.
Very well.
That is proving out.
Very well. Thanks so much. The Honorable Atta Akyea, a member of Parliament for Buakwa South.